Hi, good morning, everyone. Demaya, will you close the door for me, please? Thank you. All right, here's where we are. We got 3 classes after this. So here's what we're going to do. I'm going to lecture today and Tuesday on employment law. And then Thursday, we'll have this employment law discussion. And then the following Tuesday, that's our last class meeting. And I'm going to use that as I'll just be here if you need to come to ask questions about anything. If you have a question about the assignment I'm giving you for a final exam, which we'll talk about in a minute, I'll be available for that. So we'll just treat that as kind of a review day, but it'll be optional if you don't need it to come. I'm just going to basically be here to answer questions if you have any. For your final exam, I'm going to post an assignment, and it's going to be an ethics assignment. So you're not having a comprehensive exam over everything we've learned. It's going to be limited to ethics. And it's essentially, don't worry about getting the exact details of it right now, because I'm going to post it and we'll talk about it again next week. But essentially, I'm going to have you review a company's corporate social responsibility report. Nowadays, most big companies publish this annual report bragging about how they've done well in the areas that they are their corporate social responsibility initiatives. So the assignment is for you to review one of those, and then kind of review it critically, given some criteria that I'm going to give you. So it's kind of like a little mini report. It'll be due. I'll give you a due date, but it's something you can do anytime you want. That's why I want to go ahead and mention it. So if anybody want to go ahead and get started on it, they could get finished with it. I mean, you just do it at your own pace. So we will not meet for a final exam. We will not have a class meeting for a final exam. You'll just be turning in your report at some point before up until the due date. I don't want to get into it too much with you today because I want you to be able to read it and know what I'm talking about when we go over it next week. So we'll go over it on Tuesday. I'll post it between now and then. You're welcome to look at it, but you don't need to be doing anything. I just want to make you aware as you plan for your end of semester studying, and as you're kind of figuring out how you're going to allocate your time. You will not have a final exam that's comprehensive, that's over everything that we did this semester, and we will not meet for it. So I'm going to give you an assignment that you can just do at your own pace. Anybody have any questions about that? And again, I'm going to explain it in a lot more detail next week. That's kind of where we're headed. So employment law today and the next 2 classes next week, and then that last class period will just be if anybody has questions, or if you want help with your report, or if you just want to come in and chat. That'll be an optional class period. So the last mandatory meeting will be next Thursday. I reopened the assignments from Unit 7. I didn't do it till late last night, so if you were trying to get in them yesterday, they were still closed. I extended the due date on everything from Unit 7 till Monday the 24th. And that's because a lot of people were having some technical issues that were beyond anybody's control, like they were trying to get in Handshake and their account had been disabled or something. Anybody run into that? You're into the injury, you're into that. So has it been resolved? Not yet. Okay. Y'all let me know if there's still issues with Handshake or with technical problems. I can extend it again. So y'all just keep me posted if there's for some reason you can't get that resolved. So there were 4 things to do for Unit 7. They're all still due on the 24th. If you've already done them, you're good. But if not, you got a few extra days for that. Please make sure you do all those, because that's 4 easy 100s. Everybody's grade should be really climbing here toward the end of the semester. Is anybody allergic to or afraid of a dog, a bulldog? There's one wandering around, so just be aware. All she wants is to be petted, so she's not aggressive or non-threatening or anything, but she'll probably wander up through, and you might not see her coming, so I didn't want anybody to be surprised. Any questions? No questions. None? Anybody have anything they want to share? Nothing. Really? Daniel, what do you want to share? You got something? Nothing? Her name is Georgia. And she is dumb. Just going to tell you. It's not the sharpest knife in the drawer here. She'll probably fall asleep, but all right, let's talk about employment law today. This is one of the areas that I get kind of excited about talking, lecturing on for a couple of reasons. One is I actually did practice employment law at one time in my career, so this is one area where I actually have some experience in what I'm talking about. The other reason I'm excited is that this is a practical area of law we're talking about in terms of impact on you. You will run into employment law at every turn, either as an employee or as an employer. In any aspect of your employment, you're going to run into these issues. So this is not abstract type stuff. This is stuff that is real and day to day. And many of you who already have jobs are going to recognize a lot of what we're going to talk about as stuff you've already encountered in your employment. So to begin with, I want you to be familiar with, and I posted this these notes, this outline to the unit. So, and I did it late last night. So if you didn't check yet, you can follow along on what I posted. But I want you to be familiar with this idea of employment at will. Most states are employment at will states. And the employment at will doctrine says this, that an employer can take an adverse employment action against an employee, fire them, demote them, not promote them, not hire them for any reason, so long as there's not a law that prohibits it. So, for example, if I want to fire, who am I going to fire today? Jonathan, I'm going to fire you. If I want to fire you because you have on a hoodie, I can do that. There's no law that says that I can't fire somebody for wearing a hoodie. Okay? If I want to fire Troy because he's from, I'm making this up, because he's German, he's from Germany, there is a law that says I can't do that. That's employment discrimination on the basis of national origin. Okay, and we're going to get into discrimination a little bit today and a lot next week. If Lily is an Auburn fan and I don't like Auburn and I'm sick of her War Eagle all the time, I'm just going to be like, I'm just no more of that. You're fired. I can do that under the employment at will doctrine. So long as there's not a law prohibiting the reason, I can do it. Georgia is an at will state. There are, of course, like everything I explained to y'all, at will means you can fire, not hire, not promote for any reason, so long as it's not illegal. And then there are exceptions to that. One of them would be if there is a specific federal law prohibiting it. But there's also an exception to the at-will doctrine for folks who have employment contracts. So if you have a contract with your employer, then you're not an employee at will. You're not subject to the at-will doctrine. Your employer can only fire you, demote you, not hire you, not promote you according to the terms of your contract. So, for example, a lot of employment contracts will say so-and-so can only be fired for cause. And it will define what for cause is. Poor performance, criminal convictions, misconduct, things like that. But not things like you're an Auburn fan, you're wearing a hoodie, you get on my nerves. So all those employment at will reasons go away if you have a contract. So I do want you to appreciate that difference. Another kind of general thing that I would point out to begin with is that most of the employment laws we deal with are federal laws, passed by Congress and enforced by federal agencies. States do have some employment laws that add to or raise the bar, the minimum bar, from what the federal statutes provide. But states can't go and undercut what the federal minimum is. For example, minimum wage. Federal minimum wage statute says it's what, 7.25, which it's been for a long time. So states are free to go in and make their own minimum wage that's higher than the federal minimum wage, but they can't make it lower. I think in the earlier class we were talking about Washington State has a state minimum wage that's a lot higher than 7.25. Oh, somebody look it up. Somebody Google Washington State minimum wage. It's in the teens, isn't it? 15.75, 15.74. Where do they get 74 from? I mean, it's 15 something, so I'm not going to complain about that penny. But Starbucks, for example, if they pay minimum wage, their stores in Washington State, they got to pay $15.74. Those employees in Georgia, they got to pay 7.25. Anybody work at Starbucks? I was just curious if it's a minimum wage job or not. You do? 15? So they could in Georgia pay $7.25, but they pay 15. All right, interesting. Employment is good these days. I mean, our employment rate is low, and so there's good competition for workers, which makes people pay more. I don't know that it's been a long time since I've known anybody that's made 7.25. Daryl? 15.50 where? Oh, on Fort Benning? Yeah, minimum. So they're going up. I mean, I think one of the reasons maybe the federal government hasn't raised the minimum wage is that nobody's paying it any. I mean, everybody is paying more. I don't know that for sure, but like I said, it's hard pressed just because of competition for the workforce to get away with paying 7.25. But that's an example of just how state can increase what the federal minimum is. Yes, ma'am. You work on Fort Benning and get paid what? 12 an hour? Okay. So it's a lot higher than the basic minimum wage. Which is still, I mean, I don't know. I feel like it's about time for Congress to update the minimum wage, but they didn't ask me. All right, so that's sort of an overview of where we're headed. We're going to look at different federal laws that impact employment. The first one is, we looked at the Davis-Bacon Act is the minimum wage requirement. And then the Fair Labor Standards Act, FLSA, that provides for overtime. It covers things like child labor. Overtime, I want y'all to understand how overtime works in a couple of respects. Employers are required to pay overtime to employees who work more than 80 hours in a 2-week period. It's measured on 2 weeks at a time. If I work 60 hours this week but only 10 hours next week, that's 70 hours in a 2-week period. I'm not going to get overtime for the 60 hours I worked this week. But if I work 60 this week and 60 next week, then I'm going to get overtime for those hours above 80. Overtime is time and a half. Anybody ever get overtime? Overtime's sweet when it hits your paycheck. It's not fun to actually do overtime, but time and a half is, that feels good when that hits. So if my hourly rate is $20 an hour and I work over 80 hours, I'm going to make $30 an hour, time and a half, for every hour over 80. Not everyone is entitled or is eligible for overtime. Everyone is entitled to it. Not everyone's eligible for it. Whether or not you're eligible depends on how your job is classified. You're either exempt from overtime, meaning you can't get it, or you're non-exempt, which means you're eligible for it. The difference is in how you're classified, obviously. But the employer doesn't have just blanket discretion to just decide who's exempt and who's non-exempt. There are pages of federal regulations describing what kind of employee is exempt and what kind isn't. The main test, the main kind of litmus test for whether or not you're exempt is that if an employee's primary duty is managerial, is managerial in nature. If they exercise discretion in their job, they have judgment to perform or not perform significant matters. That looks more like management, and they're exempt. So they can work 120 hours in a 2-week period and not be eligible for overtime. They're exempt. What I want you to understand about this is that if you're an employee, you need to make sure you're classified correctly. You don't want to be misclassified as exempt if you really should be non-exempt and making overtime. It happens. An employer would much rather the person be exempt, right? So they don't have to pay overtime. So an employer would have an incentive to misclassify what should be non-exempt employees. If you are an employer, you need to make sure everybody is classified properly, because if you've misclassified someone and you owe them overtime and they sue you for it, then you could be liable for the back pay, for penalties, for some all other kind of stuff. You just want to make sure whether you're an employee or an employer that you're classified, that everybody's classified correctly. Family and medical leave is governed by the Family and Medical Leave Act. And interestingly, to me anyway, the United States is not a leader in this area. We lag behind what a lot of other developed countries provide in terms of leave for their employees. We're a little bit late to the game, and we have a real heavy dose of capitalism that influences how we look at medical leave. In this country, an employee is eligible for up to 26 weeks of medical leave in any year. It's unpaid. The employer can choose to pay you if they want to, but they're not required by the Family and Medical Leave Act to pay you while you're on medical leave. But they are required to do a couple things. They're required to keep your health insurance in place. So while you're on leave, you still have your insurance. And then when you're finished with leave, they're required to bring you back at the same, or pay attention to this, substantially similar job and compensation. It is not the exact same job and compensation. That's going to be a case-by-case basis. let's say that I make $300 an hour and I go on medical leave. And when I come back, they put me in a job that's the duties are similar to what I was doing before, but I'm only making $295 an hour. That feels a lot more substantially similar to my previous job than the employee who makes $15 an hour, comes back from medical leave, and is placed in a job making $10 an hour. We both are making $5 an hour or less. But I can make the argument that $295 is substantially similar to $300, whereas $10 an hour is not substantially similar to $15 an hour. The reason that employer is not required to restore somebody to the exact same job reflects the realities of business. Let's say that I have 20 employees, and if Carla is going to be gone for half a year, I can't just have nobody in her job for half a year. I might have to do some reshuffling while she's out. Somebody else takes over her job, but when she comes back, I got to put her in something substantially similar. There's nothing keeping me from putting her back in the exact same job. I can. Obviously, that's similar. But I'm not required to put her back in her exact same one. It doesn't also mean that employers I could bring her back and say, I'm going to pay you, 30 cents less if there's no reason for that. I mean, sometimes when you're in a big company and they've got job grades, maybe you came back as a grade 15 employee, and you were a grade 15 employee, but the salary is just a hair different because it's a different job or something like that. It might not be exact. But if I'm an employer, I want to make sure I'm really careful about bringing my folks back from medical leave to their, something that doesn't run afoul of the law. If somebody's gone for 2 weeks, then almost every time they're going to come back to the same job. I mean, most employers can just leave that job open. But if you're gone for a long period of time and if your duties are critical, then there might have to be some shuffling around. All right, what can you take medical leave for? You can take medical leave to care for a new child, new baby. You can take medical leave to care for an adopted child or a foster child within a year of adopting or the foster placement. So I can't take medical leave just to go home and care for my 5-year-old daughter. Unless there's going to be one of these other reasons. To care for new children, to care for an adopted child or a foster child placed within a year, to care for a seriously ill spouse, child, or parent. If my mother is undergoing cancer treatments and I need to take some time off to care for her, I can do that. Parent. If my spouse or my child is undergoing chemotherapy for cancer treatments, I can take some time off for that. If my aunt is undergoing chemotherapy treatments for cancer, I can't take off for that because she's not parent, child, or spouse. Obviously, medical leave covers if the employee needs to care for themselves, if they have a serious health condition. Hang on, Alex, one more thing. And then there's another, you're also eligible for medical leave if if you can tie it to military duty for a spouse somehow. Question. Brother, I think a brother does count. I think siblings count. That's a good question. My notes say parent, child, or spouse, but I think siblings do. I think you get away with siblings. Daryl. You're her guardian, or somehow legally you're responsible for her. That's a good question that I probably need to look up. But I feel like that you could probably qualify for medical leave if you're legally responsible for somebody. I think that I need to look that up for future classes and clarify that, because that's a really good point. Hold on, let me make sure this didn't quit. Let's hope it goes for the rest of the time. No guarantee. So a couple of things that, as I read through that list, that hopefully by now in this semester I've got your ears trained to hear. When I say that eligibility is to care for a seriously ill spouse, parent, child, the law doesn't then go on to define seriously ill. So that's gonna be up to some interpretation from the judge or jury. To care for themselves if they have a serious health condition. That phrase is subject to interpretation. That prevents them from performing essential job functions. Again, going to be case specific. So when you hear language like that, I hope it will trigger in you thinking, all right, got to make sure that my facts fit under those guidelines. So that's FMLA. Any questions on family and medical leave? I skipped over this real quick, but in order to be eligible to take or apply for family and medical leave, you have to have worked at your employer for at least a year. So you can't get a job one day and then the next week take medical leave. You got to have been there a year first. Jonathan. Would that include who? What family? A death in the family. I don't think it covers that because I don't think it's going to fit under one of the definitions. A death in the family, well, let's unpack that for a second. If you need time off for a funeral, almost all jobs would just say you just got to use your vacation days for that. But let's say somebody died and then you had to then take care of the surviving spouse or child or something like that. That might qualify. But I don't think that the death itself is a condition that gives eligibility. I think it's the idea, the act of having to care for somebody to be away from work to do that. Does that make sense? Anybody disagree with that? Did I already ask you, anybody ever had any experience with family medical leave? No one? All right, well, hopefully you don't ever need to. We are going to do a discussion question next week, not for this week, but next week. And part of the discussion that you're going to be responsible for is I'm assigning you just a really, really short newspaper blurb article about how other countries handle family medical leave. And I will just want your opinion on how we do it versus how other places do it. Most other developed nations have mandatory medical leave like we do, but theirs is paid, meaning the employer has to pay the employee while they're out on medical leave. We don't have that, but a lot of countries do. So I'm going to ask you to sort of think through the pros and cons of that setup. Health and safety intersects with employment in that obviously we have a right to be safe on our job, not subject to dangerous work environments, getting hurt on the job. And that looks like a couple of different things. One is the Occupational Safety and Health Act. That's the federal statute that provides for workplace safety. It's very general and will say things like workplaces should be safe. The devil is in the details of what OSHA, when they make their regulations about what makes a safe workplace, there are volumes and volumes of rules. Anybody deal with OSHA? Remember at the beginning of the semester when we talked about administrative law being the rules created by administrative agencies? So the main OSHA statute just says workplaces should be safe generally. And then the Occupational Safety and Health Administration the body who's charged with administering OSHA, they make all the rules about what makes a safe workplace. How tall your ladders have to be, how far the rungs are spaced apart, that you have to put down the wet floor signs everywhere. I had a student in my earlier class who's from England, and she asked if it was an OSHA requirement to put in the bathroom the sign that says employees must wash their hands before returning to work. I don't know. I bet it is. But I don't know that. But I bet it is. She said they don't have that in England because they don't need it. I was like, well, we do. So I do think that's probably an OSHA regulation. But that's the Occupational Safety and Health Act. Comes into play mostly in manufacturing environments, factories, warehouses, things like that, where the job duties involve more safety-related things, or where you have more work-related injuries. There's also states have set up. This is an area where it's really mostly state law, not federal, but workers' compensation works pretty much the same from state to state, and it goes like this. Basically, an insurance company for employers. Every employer contributes to the state workers' compensation fund, whether or not that employer has employees who've been hurt on the job or not. So every time I pay payroll taxes from my law office, I'm paying money into the state workers' compensation fund, so that any employee who's injured on the job gets paid from that state fund that we all contribute to. It doesn't come out of the employer's pocket for the specific employee that got hurt. It comes from the big fund that everybody pays into. I might pay into that fund my whole career and never have an employee make a claim for workers' comp. I also might pay into it my whole career and have a ton of employees make claims that pay out more than I contributed in. That's just how it works. Everybody pays into it. The trade-off so it's a good deal for employers in the sense that they basically have insurance for injuries that happen on the job. They're not paying out of their pocket for it. They're just doing that payroll contribution periodically. The other good deal about it for employers is that if an employee files a workers' compensation claim, they want to be paid from the state fund for their injury that they incurred on the job, then they can't sue the employer. So the employee can't recover twice. Can't go to the state unemployment insurance fund and recover from that and then sue the employer and recover from the employer too. It's got to be one or the other. There's some exceptions, but generally speaking, that's how it works. If you would rather sue your employer, you can. You just can't also apply for workers' comp. If you think you'd get more money, it'd be a better case, it'd be more beneficial to you to sue them rather than get workers' comp, you can always do that. You just can't do both. So that's how workers' comp works. Anybody had any experience with that? All right, unemployment is similar to the way workers' comp works, in that employers pay into the state, the unemployment insurance fund through their payroll taxes. And then if an employee loses their job, hear this part, through no fault of their own, they can apply for unemployment benefits that get paid from that general fund. Again, not coming out of the employer's pocket directly, but coming out of the contributions of all employers through payroll taxes to the main fund. So I might never have an employee make an unemployment claim, but I'm still paying into it. I also might have several employees make claims on unemployment that pay benefits that are more than what I've contributed. Similar to workers' comp, that's just how it goes. The through no fault of their own part is a little bit tricky because that, again, is going to be a case-by-case basis. If I get fired from CSU because I don't know, because I failed a drug test for meth. So let's just say. I don't even know what meth looks like. I promise I don't know what meth looks like. If I fail, and that's really not funny. I mean, meth is a serious addiction, and I see the devastation that it causes. But if I get fired because I do meth in class, I can't get unemployment insurance. I've been fired for my own fault. But if I get laid off because there's a budget cut, they're eliminating my position, or I'm restructuring or something, or they're restructuring, and that's not my fault, I can apply for unemployment. Unemployment is only for a short period of time. It's not forever and ever. It got skewed a lot during COVID because a lot of jobs got eliminated and the government just paid extended benefits. But generally speaking, unemployment only lasts for a short period of time. Depends on state, what that state decides. I'll give you a quick illustration of unemployment. I've never had more than one full-time employee in the last 15 years since I've had my own business. I've had some like part-time here and there, but really only one full-time employee. And the first one I had when I went out to work on my own 15 years ago, I liked her a lot personally. We got along very well. But over time, she just wasn't getting her job done, and she was keeping up with the Kardashians on work computer during work hours, and doing whatever that stupid game is where you have to pick the strawberries. What game is that? You know what I'm talking about? Where you're farming or something and you have to log in all. Maybe. It's like, oh, I got to pick my strawberries. I was like, okay. So I decided it was time to let her go. And so I sort of let her down easy, and I wasn't real specific. I mean, I just figured, I didn't have a lot of experience in doing this. I just figured, I like her personally. I'd gotten to know her family. There's no point in, I mean, I'm going to let her go, but there's no point in me piling on and being like, and you were watching TV and you're doing crappy work and all. So she applied for unemployment insurance, and I objected to it because she had, in my mind, been fired for cause. And we had a hearing on it, and she won. And they said that I had not given her warnings. I had not let her know that her job performance was slipping. I had not done so-and-so things. At the time, it really pissed me off. But looking back, I'm like, yeah, I probably didn't. I didn't lay a good enough foundation for it, even though I felt like watching TV while you're supposed to be working is cause. But anyway, why did I really care? It wasn't necessarily the principle of the matter, although it was a little bit that. But the more employees that an employer has that claim unemployment, the higher their percentage rate contribution is. Their rates go up. So I didn't want to contribute more to the state unemployment insurance fund. They were going to ding me and up my percentage because I had somebody claim it. And I didn't like that at the time. Looking back, it did not matter. It really didn't matter. I would have probably done things differently now than I did then. Yeah. It is always best to keep everything documented, no matter what area we're talking about. I'm a big fan of documentation. Absolutely.
Probably don't have an answer for this, but let's just say that the manager doesn't like you, and then they like
Yeah, so that the question is for people watching on video. What if your employer just doesn't like you and they fire you? You don't really get warning or counseling, but then they object and then try to say later on that it was performance based. I think that employers are going to lose a lot of the time on that. That's what happened to me. The lesson from that was that I needed to be better at documenting and I needed to be better at counseling my employees when their performance was substandard and not just, up and firing them one day. But I mean, I think if an employee's performance was bad, but they weren't ever told about it, I think they're going to get unemployment insurance. I really do. I mean, it would depend on the decision of that hearing officer, but I think they will. I'll give you another example, and I'll come back to your question. One of my clients is the health department in LaGrange, and they are my client for employment law purposes. They call me with their employment law questions. And a lot of times they don't want to say, for whatever reason, they don't want to get into why they fired somebody. They just want to fire them. And I'm not saying to cover for an illegal reason. I just mean it just wasn't working out and it's just not worth getting into. And they will say, we're just gonna terminate them because they're an at-will employee, and we're gonna let them, if they want to claim unemployment, they can. We don't care. That's easier to us than having to get into it with disagreements about whether performance was substandard or not. If they're an at-will employee and you don't care if they're going to get unemployment, to me, it's always better just to say, to not give reasons. So that's how that goes down sometimes. Now, sometimes they'll call and say, we would object if this person applied for unemployment. And so in those cases, I make sure that their termination letter and all that stuff clearly spells out why they're being terminated for cause. Again, that employee can still challenge that. I'd still have to prove it if it got challenged, but I'm really careful about that. The next time I had to ever let an employee go, I was real specific about it, and I wasn't going to say mean, but I was like to the point, like, here are the reasons that you're being let go, because I didn't want to make the same mistake I did the first go round. That person did not apply for unemployment. So, any questions about how that works? We're not really going to get into too much in this class, just because for time purposes, but Social Security is an employment law, and employers have to contribute to your Social Security account every pay period. And then when you reach retirement age, you can then start drawing Social Security back from the government's fund that got paid into, depending on the rate that you get depends on what age you decide to ask for it. If you ask for Social Security at like 62 and a half when you're first eligible, you won't make as much as
That really threw me off because I didn't see him the whole time. And he popped his head out. I was like, is that a dog? He's so cute.
almost tripped over. Yeah, she is they've been bred to the point where they can hardly breathe. It's really kind of sad. So Social Security, it just depends sort of on when you apply. The earlier you apply, the less you make. The longer you wait, the more you'll make on Social Security. Well, that's how that works. I do want you to know about COBRA. I'm sorry, Carla, yes, question.
Whatever the numbers are, ends with a K.
401k. Yes.
And so does your employer have to match that?
No,
Oh,
they
that's
don't.
an option for your
Yep,
employer.
that is it. If your employer matches contributes to your retirement fund, that's a great benefit. That's wonderful. If you haven't, that's a benefit of employment, but it is not mandated by law. COBRA requires that if you lose your job, even if it was your fault, the employer still has to give you the option of continuing your health coverage for 18 months after employment ends. And that ensures that if somebody loses their job, that they're not going to all of a sudden be cut off from health insurance. The catch is, though, that COBRA benefits, if you want to continue that health insurance for 18 months, you got to pay for it. So if your employer was paying for it before and they fire you or let you go, you're still eligible for the health insurance if you want it, just out of your pocket. Most people don't use COBRA because it's cheaper to just go get a coverage in the marketplace. It usually costs more, but I mean, I feel like that varies from year to year, and depending on, it varies by employer, it varies by, I don't know. Health insurance is that's a whole nother topic unto itself. But you do need to know that if you lose your job, whether it's your fault or not, you can still keep your health insurance if you want to pay for it for 18 months. That is COBRA. We don't get into too much in this class about immigration law, but I do want you to know that there is an intersection between immigration law and employment law, in that your employees have to be here legally, either as citizens or they have to be here on an approved work visa so that the governments give them permission to be in the country to work. If you ever filled out as part of employment, almost every time at the beginning, your intake packet contains that I-9 form. That certifies that you're here legally. So when the government comes to audit a business that may have illegal workers, they've got to have an I-9 form for everybody. Anybody have any experience with running anything along those lines? Good. We don't really get into too much more than that. All right, I want to get into employment discrimination here. And I want you to think about it in a couple different ways. One is discrimination against an individual based on a characteristic or a fact or a perception. So, for example, me firing someone or not hiring someone or not promoting someone because of their gender, because of their race, because of the country they're from, because of their religion, because of their sexual orientation. That's illegal. That is discrimination against an individual. We call that disparate treatment. I'm treating one individual differently than another based on gender, race, national origin, religion, things like that. Okay, that's an intentional discrimination. But there's also an area of discrimination that's unintentional, meaning there's no malice about it. There was no discriminatory intent, but the result of an employment practice was discriminatory. We call that disparate impact. The disparate treatment is discrimination of the individual. Disparate impact is discrimination against a group. And it looks something like this. I give a aptitude test to all applicants for my sales job. I'm a big company, and I hire a lot of salesmen, saleswomen, salespeople, and I give this test. And let's say that over a 3-year period, I've had 5,000 people take the test. And I've had exactly 50% of the applicants are women and exactly 50% of my applicants are men. So I've had 2,500 women take this test and I've had 2,500 men take the test. And the women score significantly higher than the men on the test. Just as over a 3-year period, systematically, the women always score way higher. And so they're the ones getting hired for my sales job. No men are getting hired in my sales jobs because they're not passing the test. You could look at each question on my test and they might all be on their face non-discriminatory. There might not be anything wrong with the question, but there's something going on with my test that's resulting in discrimination against the males. They're not getting the job because there's something about that test that's not intentionally discriminatory, but unintentionally it's resulted in discrimination. So is that hard to prove? Yeah. Disparate impact is harder to prove. Because what we're really saying is, all right, this is the result of this practice, of this hiring policy or practice, and we suspect that the reason is discriminatory, not on purpose, but there's something about it that must be discriminatory or else we wouldn't be getting these results. Again, very hard to prove. If I've got specific questions in my test that are clearly designed to favor women over men, and you could read it and be like, well, that's discriminatory. That might be more disparate impact, intentional discrimination. But I'm saying that there could be there are facially neutral policies. The idea of giving a test and letting the highest scored people who score highest on it get the job, that's not discriminatory in and of itself. The idea of awarding the job to the person who scores the highest, that's as non-discriminatory as it gets. But if the result is that somebody is being discriminated against unfairly or disproportionately, I might have disparate impact discrimination. The larger my sample size, the more likely I've got a problem. If I have 3 people apply for a job and I give them all the same test and 2 women took the test and 1 man, that was my applicant pool, the man scored lower than the women, going to have a really hard time proving disparate impact discrimination on a sample size of 3. They're going to have an impossible time proving disparate impact on a sample size of 3. But if I've got 300,000 people that have taken this test over the years and no men are getting the job, then that might be a little easier to prove. Again, be a costly, long, expensive, complicated lawsuit, disparate impact. But it is possible to discriminate unintentionally. So, what does it take to be in, or let me rephrase that. How do we know what is a protected class from intentional or unintentional discrimination? How do we know that we can't discriminate on the basis of race, gender, national origin, religion? It goes to the certain specific federal laws. So the first one I want you to be familiar with is Title VII of the Civil Rights Act of 1964. You'll hear it referred to just as Title VII in the employment context. That's what that means. 1964, in some ways, sounds like a long time ago. But in some ways, if you think about the fact that it was legal to discriminate before 1964, it doesn't seem all that long ago. It hasn't even been illegal for 100 years yet. to discriminate on those against a protected class. It seems old hat to us now, but there are people alive who would remember a time when it was okay to fire somebody because they were pregnant or because they were Muslim or because of their religion. Title VII, I'm not going to expect y'all to know which law covers which protected class. I'm much more interested that you know what the protected classes are. But Title VII, just for your information, is race, national origin, religion, gender. We also can't discriminate on the basis of disability or age, but those are different laws that we're going to get to next week. When Title VII was written in 1964 and passed, it originally did not include as a protected class sexual orientation. There was a Supreme Court case within the last 5 years. It was actually started, the case was out of Georgia, where an employee of the government, the state government, claimed that he was fired for being gay. And up until that point, any employee who had challenged Title VII or challenged their employer for firing them under Title VII, the courts had said Title VII does not cover sexual orientation. We're reading the statute and the way it was written in 1964, we don't interpret it as covering sexual orientation. And oh, by the way, the courts would say, if Congress wants Title VII to cover sexual orientation, you know what all they got to do? Amend the law. But if you're asking us to read the statute and interpret, does it cover that? No, it doesn't. Up until a few years ago when the Supreme Court decided all of a sudden, you know what? We are going to read this law as also covering, prohibiting discrimination in employment on the basis of sexual orientation. So it is a protected class now under Title VII that was not originally under Title VII. Interestingly enough, even if a person isn't a member of a protected class, but they have an adverse employment action, demotion, not hiring, firing, and the employer perceives that person as being a member of a protected class, that's illegal. So I might not be actually from Germany, but if my employer fires me because they think I'm German, that's hard to conceive of. There's a lot of Russian bias right now from the Russian war. Let's say that I'm not Russian, but CSU thinks I am. Or there's some perception they have of me that I'm somehow a Russian sympathizer or something. And they fire me because of that. Even though I'm not actually from another country, if that was the reason they fired me, I could still be protected. I could still be a member of that protected class. Trying to think of if I'm at a good stopping point. I want to talk real quick. I think I'll do this and then quit. If an employee wants to allege discrimination, wants to sue the employer for discrimination for any of these federal laws, not just Title VII, disability, age, all the other reasons that we'll talk about next week. This is one of the few areas that you can't go straight to the courthouse and file. You have to first file a claim with the Equal Employment Opportunity Commission. That's a federal agency known as the EEOC. You have to first file a complaint with them before you can go to court. It's like getting your ticket to go to court. You get it through the EEOC claims process. And it's kind of a mini legal process in that, let's say I believe I've been discriminated against because I'm Methodist. I was fired, CSU fired me, and I believe it was because of my religious beliefs. I have to go file a claim with the EEOC. I've got to state what my claim is, why I believe I was discriminated against, got to show any evidence that I have. And then CSU, if they want to, can dispute it with the EEOC. And the EEOC is going to issue a finding. They're either going to, well, I want to confuse you too much. The EEOC doesn't decide whether the employer did it or not, but the EEOC does do an investigation, and they issue at the end of their investigation, they give the employee a right to sue letter, which is just your ticket to go to court. They might also issue a finding of no discrimination, but you still get your right to sue letter. So even if the EEOC doesn't find that there was any merit to your complaint, you can still sue. It's not you get your ticket no matter what. And so a lot of employers will not get very involved in the EEOC complaint process because the employee is going to get a right to sue letter either way. And the employer feels like, I don't want to go ahead and give away my case right now, or I really don't want to litigate in front of the EEOC. I'd rather just wait, and if the person wants to sue me, they can sue me, and well, I'll just handle it in court. That's one reason an employer might not want to fight it. Another reason is that if an employee, this is the advice I give my employment law clients all the time. If you are going to go through the EEOC process and dispute a claim or respond to a claim, you got to be really thorough about it. Because anything that you don't say in the EEOC process that you later on say in court is going to look suspicious. If I don't say that the employee was fired because of bad performance in the EEOC process, but then when we get to court, I'm like, oh, they're not. I didn't fire them because of their religion. I fired them because they were consistently did terrible work. Well, that other lawyer is going to be, really? That's funny, because when you responded to the EEOC complaint, you didn't say anything about you never said anything about their performance. When you fired them, you never said anything about performance. You're just now saying it's their performance because we're in court. So you just have to be really careful from an employer standpoint. Employers think strategically about positioning their case for an EEOC claim versus one in court later. There's just a lot that goes into that. I had one boss way back when I first started practicing law, and I was in employment law, and he said, I tell our clients, for the EEOC process, just don't respond at all. If the employee wants to sue us, let them sue us, and we would just rather, and this was a big company that had the resources, we'd rather just litigate than give somebody a preview to our case or say something that might trip us up later. On the other end of that spectrum, I've had a client who we did decide to respond to the EEOC complaint, and the response was so thorough and so overwhelming that the employee just said, forget it. Never mind. I can't win this. Then most likely the employee's lawyer was like, yeah, you're screwed. You got no case. So for that employer, it did benefit them to go ahead and respond during the claims process because it prevented a lawsuit. It's a strategic decision on a case-by-case basis. I think that my phone is about to die, so I'm going to stop. But so let me recap once again for anybody who came in late. All your Unit 7 assignments have been extended through April 24th. Anybody needs an extension on Unit 7 stuff, let me know past that because I know there's some issues beyond our control. You don't have any Unit 8, no employment law assignments between now and next Tuesday's class. Everything we do for this unit will be due the next week. So on Tuesday, I'll see y'all. I'll finish my lecture. We'll talk about the final, and we'll go from there. Anybody have any questions? All right. Y'all have a good one. Yes, ma'am.